Hello, it's Caitlin Jenkins, the family law vlogger here, and this is the next in the stages of divorce vlogs. Today, I'm going to talk about valuing property in the context of divorce and trying to sort out the finances. So, although we'll talk in a separate vlog about commercial property, this is really focusing on a property that people live in, so a home, or other residential properties that they own, so maybe some buy-to-lets or an interest in another person's property, for example, maybe a parent's property. So first of all, what information do you have to disclose with Form E? Well, save in very exceptional circumstances in relating to domestic abuse and a home that somebody is living in a Form E, you need to disclose the full address of a property. And that's not just the home you live in, it's any property that you have an interest in. So whether you own it in your sole name, whether you own it jointly with your spouse or somebody else, or whether you have an interest in it. For example, you've invested in a property and under some sort of arrangement with a third party or your spouse, you have a beneficial interest in that property. So I suppose the first thing to say is the disclosure of property in financial proceedings is broad. It involves any interest in any property, however you own it. You might need some advice on whether a particular interest in a property, a beneficial interest, for example, in a property that you have an interest in, but you haven't funded, whether that needs to be disclosed. So this is an area that you may need some advice on if you've got more than, say, the family home that you're living in with your spouse or used to live in with your spouse. The second thing to say about property is that you also have to disclose any mortgage or other loan on the property. So for a mortgage, you'd have to disclose the details of the mortgage company, the amount outstanding. You'll have to get a most up-to-date redemption statement from the mortgage company to show how much is outstanding and whether there'll be, for example, any early redemption penalty and what the mortgage payments are. So that's some documentary evidence you'd need to get together to show any mortgage on the property. And then the third thing to think about is, well, how do you value the property? And we're talking mainly here about, say, a family home. Well, sometimes people know instinctively what the value of a property is, and it's not a controversial point, and them and their spouse know the property and the property values in their area and are happy to agree a value. If they can agree something, then that's great. If you can't agree the value of a home or value of the homes, for example, buy-to-let properties, then the first starting point often is to get, say, 2 or 3 local estate agents who specialise in properties in the area that the property's in to provide a marketing appraisal for the property. Now, they may call it a valuation, but in effect, it's a marketing appraisal. It's saying to an estate agent, if we were putting this house on the market, what would you suggest we should market it for? And importantly, what sort of price would the agent expect to achieve? Now, most agents will do this for free, and they will give an indication, usually in writing, of what they think the property should go on the market for and the sort of bracket within which they would hope to sell the property for. And just because you're asking an estate agent to value a property for this purpose, it doesn't necessarily mean that you're conceding that the house should be sold, because in some circumstances, that's not what somebody wants to do. They want to keep the house or have it transferred to them. But getting it valued is important. So the court or in any negotiations, it can be factored into the discussions about what happens to that property. So getting it valued is important. It isn't necessarily conceding that it'll be sold or transferred to somebody else. So if you get 2 or 3 marketing appraisals from estate agents, often you get an idea of the sort of bracket of the value of the property, and the agents come in a sort of similar vein, and you can agree that the value of the property based on the advice from 2 or 3 local agents is approximately a certain amount. If you can't, or if there's still a dispute about the value, then either by agreement or the court can order it in a court process if it feels it's necessary and proportionate, can direct that a chartered surveyor provides what's called a red book valuation, so a formal valuation of the property itself, having looked at it. So it's not just a marketing appraisal, it's actually a surveyor's red book valuation of what the property is worth. Now, there's usually a cost to that, and depending on the value of the property and the location, that can be a significant sum, but it depends on the location. If it's ordered by a court to have a valuation, then it may well be that it's a single joint expert valuation. So the valuer is instructed on behalf of both people, and they usually in that circumstance meet the cost of the surveyor equally. And that valuation would then be the valuation that, again, save in exceptional circumstances, would be used in the financial negotiations or in the court for putting the value on that property. So that then is the headlines around how you value property, different ways to go about it, with a view to then being able to use that valuation for the purpose of negotiations or in a court context of negotiations. As always with the Family Law vlog, If you have any queries about your circumstances, then please do contact me or one of my colleagues in the specialist family and children team at Mills & Reeve. Thank you.